Good afternoon, everybody. Thank you, everyone, for joining us today. We've got an incredible panel. I'm very enthusiastic and honored to be chairing this and moderating this great panel. Just to get started first, on your screen, you'll see the BHBA currently has 3 different levels of membership. You can kind of see underneath each one the different things that come with that, and one's the professional, the sustainer, the economy. I believe there's also one of those includes free membership for students. All of these details can be found on the website bhba.org/membership. And also, if you the BHBA offers if you need access to work from home, to access professional business services like daily mail scan and conference space. You need a business address in Beverly Hills. Check with the BHBA offices, and they have different plans and offerings for that as well, which you can also find on bhba.org/virtual office. And last but not least, one of the things that I'm involved with, I'm the chair of the network, which is the Beverly Hills Bar Association's networking program. It meets the third Monday of every month in the afternoon, and it's a great way to get out there and meet other attorneys, other members of the BHBA in different fields, and meet and mingle with industry professionals and build your business out and just network. It's right there in the name. And with that, we'll go ahead and get started. Just to let me quickly introduce our panel. I'll start with Jordan Bromley. Jordan is the leader of Manat Entertainment Transactions and Finance Practice. Jordan's client base includes, among many different groups, iconic, established, legacy, and developing artists, songwriters, producers, record labels, digital distributors, streaming content companies, and music publishers. Jordan is also known for his thought leadership on the Music Modernization Act, which we will definitely be talking about today, streaming trends and copyright and royalty issues. He is frequently published in and quoted by publications covering music issues such as Billboard, Newsweek, Entrepreneur, and The Guardian. Jordan has been recognized by Billboard as one of music's most powerful attorneys. Next, we have Jeff Brabeck. Jeff is Senior Vice President of Business and Legal Affairs for BMG Rights Management. Jeff specializes in evaluating, analyzing, projecting income, and negotiating music publishing catalog acquisitions. Jeff is the co-author of the best-selling book, Music, Money, and Success, The Insider's Guide to Making Money in the Music Business. Variety magazine selected the 8th edition as one of the best music books of 2019. Jeff is also an adjunct professor at USC Thornton School of Music Business Division, where he teaches music publishing and licensing. He is also on the board of the Mechanical Licensing Collective, which was established by the Music Modernization Act, which is also something we'll be talking about today. And last, but certainly not least, we have Don Passman. He's the author of All You Need to Know About the Music Business, now in its 10th edition, and a graduate of the University of Texas and Harvard Law School. He practices law with the Los Angeles firm of Gangtire, Raymer, Brown, and Passman, and has specialized in the music business for over 40 years. Don has lectured extensively on the music industry. He has been listed in the best lawyers in America for over 20 years, as well as the top 100 lawyers in California, among many other accolades. Let's go ahead and get started, guys. Welcome. Great to see you guys. So we wanted to start out, I think, dealing with, certainly current events, but let's start off with some of the non-COVID related issues. And one of the things that a lot of people have been asking about is the recent AB-5 and how that's affected the music industry. And largely it was aimed at gig economy jobs such as ride-sharing companies like Uber and Lyft, and was designed to make it more difficult for those types of companies to classify workers as independent contractors rather than employees. But it had some effect on the music industry. And Jordan, I know you've been working on getting an amendment passed, which I believe has just recently been passed. Why don't you lead us off and talk about that and what was approved and why it was necessary?
Sure. Yeah. So AB-5 was a bill that passed the Assembly last year this time, signed by the governor, took effect at the beginning of 2020. And what it would have done for the music business was essentially turn anybody in a recording session or a songwriting session into either an employer or an employee. As most attorneys know, the burdens of being an employer is pretty strict, especially in the state of California. A lot of extra heavy lifting in terms of putting people through payroll, tax withholdings, workers' comp insurance, providing a safe workplace, and all sorts of stuff is imposed upon employers. And if you're inviting a friend over to play guitar on a track that you're recording on a Saturday, it really wasn't intended to cover a situation like that, or a host of other relationships in the music business. So the gig economy started with us, right? The jazz musicians. So we defined it and created it, and it's gone off to other industries. But the idea was, hey, let's keep it as it was here. We have a very vibrant music community and economy in the state of California, and you really don't want to mess with that. So that was the problem. And the solution was found over the course of about 9 months of negotiating between companies and unions. And last April, we came to a consensus. And one thing I learned, as it being my first piece of legislation that I was helping to pass for the music business, is once you have a consensus amongst most of the stakeholders in a state, it kind of moves lightning fast through the assembly, where it was voted unanimously, an A vote, and then to the Senate, where it was voted unanimously as an A vote, and then to the governor's desk, who it was one of the first bills he signed out of session 2 weeks ago now. So it's the law. The music business has our exemption, and it's effective immediately and retroactively.
Jordan, who of does it cover all music professionals, or are there certain people who are exempt and some that may still not be?
It covers a vast majority in the kind of music making and promotion ecosphere. There are some exclusions. We have unions that have collective bargaining agreements with labels, and those collective bargaining agreements stay in force, and so unions are able to represent their members properly and enforce the terms of the collective bargaining agreements and get payments pursuant to those. But yeah, I would say about 95% of coverage is there to preserve the status quo. And I always joke that I've never worked harder than to preserve status quo. Normally, you work this hard to change something, and we work this hard just to keep it the same, because it was going all right, and we'll continue to now, fortunately.
For any of the music professionals tuning in, Jordan, do we know when the amendment's going to take effect?
Now, it's in.
Oh, it's in. Okay. Yep. So, all right.
Yep.
That's great.
Yep. So, and I will caveat for, this is a lawyers panel, right? And I'm assuming a vast majority of the attendees are lawyers. This does not make anyone a de facto independent contractor. It just applies the old standard, which is commonly known as the Borello test, to the determination of whether someone is an employee or an independent contractor. So it is not the independent contractor exemption. It is the Borello rules that now apply instead of the Dynamex rules that the Supreme Court adopted in 2018. California Supreme Court adopted in 2018. So you still have to run the analysis.
Great. Well, I'm sure that's going to be, good news for music professionals, and I'm sure everyone's happy to hear that. I don't know if Jeff or Don, if either of you wanted to chime in on that at all.
No.
Okay. So let's talk a little bit about the Music Modernization Act, and there's been some. It was signed into law in October 2018, I believe. So let's talk about some of the implementation procedures that have gone into effect so far. Jeff, do you want to talk about the Mechanical Licensing Collective and
definitely.
what that is, and what its purpose was, and how it was formed?
Definitely, it'd be my pleasure. Before I get into that, let me just explain the actual right, the royalty provision that's actually that the MLC, the Mechanical Licensing Collective, deals with, because it's one of the areas that is actually increasing in value as opposed to decreasing, you know, such as, you know, the downloads are decreasing, but there's a mechanical royalty or a distribution royalty in interactive streaming. Now, interactive streaming is basically where the consumer can choose what they want to hear, not the channel, not the type of music, but the actual composition or actual recording of a composition. You look at the Spotifys, the Amazons, the Apples, Pandora to a degree as well. What the Copyright Royalty Board did at the start of 2018, they established rates for this interactive mechanical royalty for a 5-year period from 2018 through 2022. And unlike the simplicity of the download royalty, 9.1 cents per download or 1.75 cents per minute if a song is longer than 5 minutes, we're talking about complicated formulas that have a number of different aspects. So this is not a very simplistic, you know, type of approach to royalties, but it is what the Copyright Royalty Board provided for. In effect, in its simplest form, if we take an ad-supported service, there are two major factors. One is the percent of revenue, the revenue to the service, and the other is the monies and the license fees of that the service pays to the master recordings owners, the record companies, for the use of the masters that contain the compositions. In effect, what the CRB said, we're going to take the greater of the percentage of the revenue to the service, or percentage of the amount of money that the service is paying to the record labels, then we will deduct the performance royalties that go to ASCAP, BMI, CSAC, and GMR, and that will result in the mechanical rate for each particular composition. It gets more complicated if it's a subscriber base, because then you add subscriber information in and a per subscriber dollar amount. But whatever is the greatest of all those figures is this mechanical royalty that interactive for interactive sites. Now, what they did, in the percentage of revenue, they went from 2018 for 11.4% of the revenue of the digital service to 15.1% in 2022. They did the same thing with the total content costs as what the record companies pay to the master recordings, from 22% in 2018 to 26.2% in 2022. Basically, what the CRB did was, over a 5-year period, give an increase to music publishers and songwriters and composers and lyricists, basically a 44% increase from what the rates were in 2017. So that's the overall concept of what the rate is. When I tell you it's the complexity, and this is not in the slide, but I'll just kind of show you. This is a summary sheet from one of the societies. This was our digital services, Pandora. It has line items from A to X with multiplications, subtractions, et cetera, to arrive at the final effective per play rate to be paid as mechanical royalty. In this particular case, in June of 2020, the mechanical rate per performance would be 0.000618. You can see a lot of decimal points. It doesn't sound like much money, but when you're getting millions of streams, these things do add up. And this is the wave of the future. So the good thing about what the CRB did, was that they increased it over a 5-year period. Now there's an appeal, which Jordan and I can talk about as well, but that's the right that I'm dealing with. Now the Mechanical Licensing Collective, which is known as the MLC, and please, there's a lot of information on the website. The website is themlc.com. It'll answer a lot of questions, but it's probably one of the most important organizations that have been created in a long time. And it was created by the MMA, and it's supervised by the U.S. Copyright Office. In effect, what it does, and it's a not-for-profit organization, which is funded by the digital music companies, funded by the Spotifys, the Amazons, the Googles, et cetera. So so they're paying the freight on this organization. The point of the organization is to manage and issue blanket licenses, just like an ASCAP or BMI blanket license, to the digital services so that they can perform all the music in the repertory of the MLC. So it's a blanket license, which is important. Our role also is to collect the royalties from the digital services. They're statutory royalties, obviously, and then pay the correct copyright owners, the music publishers primarily, who will then distribute to the songwriters their proportionate share. Now, who needs to join this organization? Two separate parties. One are music publishers, obviously, who control the mechanical rights. The others are the self-administered songwriters, those songwriters who own their own publishing and therefore own the right to license their mechanical rights. So two separate parties. Now, whether you're a big publisher or a small publisher, there is no fee, but just like Sound Exchange, it's an essential element of collecting royalties in this digital area. One of the most important things that we have on our plate is to, first of all, build a database, which hopefully will be the most complete database as who owns the mechanical royalties, mechanical rights in the United States. And once again, this is a U.S. Situation, although foreign societies and foreign composers and publishers, if they own their mechanical rights, can also join as well. But what we are doing is tracking U.S. rights, U.S. performances, U.S. mechanical income. And we are establishing a portal which should be available in about 3 to 4 weeks, where publishers and composers, lyricists, and songwriters will be able to go in and see if their works are correctly, properly credited, as far as shares go, publishing interests, et cetera, so that they get paid. And one of the last things that is vital is that our role is to help match all the unmatched royalties that have been held by the digital music providers so far, and any unmatched royalties from unidentified or misidentified compositions for performances in the future. That's going to be an essential role of the MLC, and we're putting a lot of effort into the database. We're putting a lot of effort into making sure, publicizing the fact that people can go into this database, check the compositions, check the information, tell us where the disparities lie, so that we can do something about it. And that's basically the entire thing. Just a couple quick areas. It's the board. There's a board of directors of 14 individuals. There'll be 10 music publishers, 4 self-administered songwriters. There are large publishers, there are independent small publishers, there are 4 really excellent songwriters. I'm privileged to be on the board representing B&G. There are also, there are 3 non-voting members, one from NSAI, which is Bart Herbison, one from the NMPA, Daniel Agori, and one from the digital service companies. I have my NSAI t-shirt, and so hopefully Bart will smile. And that's the board. There are advisory committees. The advisory committees are basically, just hang on one second, a dispute resolution committee. We are not going to get into deciding, disputes, but we will try to intercede and help people with disputes by giving them what information we have, and hopefully they'll come to a resolution. There's an operations advisory committee which has to deal with music publishers, songwriters, and digital service companies on it. And then there's a unclaimed royalties oversight committee who are supposed to help with the unmatching of these royalties. Once again, as I said, the digital services will be paying for the costs. They've already contributed $33.5 million for the startup situation. There's a budget of $28.5 million for 2021. And it's just an essential organization that everyone needs to join to be able to collect their royalties, for mechanical royalties from the digital services. And the good thing is there is no fee to the publishers or songwriters because the digital companies are paying everything. Whatever money comes in, the statutory royalties will be going out without any deductions. That's an overview. There's a lot on the site. Once again, the MLC.com. But we're getting very, very close to operational status. We start on January 1st, 2021. The portal should be ready in about 3 weeks. We already have a digital or qualitative test where you can actually send in, list all the compositions you own. We'll come back with a report about are there any disparities, differences, et cetera, so you'll know what we have and what you have and you can resolve that. So that's an overview of the MLC. But as I said, very important organization and extremely important right because it is one of the areas in the music industry which is increasing.
Jordan, did you want to add anything to that?
I actually had a question. Jeff, do you know, like, the DSPs that have previously been licensed, instead of going statutory, is the rate for all DSPs now going to be the statutory rate that goes into the MLC?
Well, we're talking about anyone who goes through the MLC will get the statutory rate. As I think all of us know, certain large publishers and certain publishers have direct deals with the DSPs. So the royalty stream could be different than the statutory royalties because there might be other advantages or other benefits that have been negotiated to get a direct deal. So, but the royalties that go through the MLC will be statutory royalties. So
there are royalties that might not go through the MLC that are mechanical royalties in the United States.
That's correct. If you have a direct deal with, let's say, Pandora or Spotify, those royalties will go directly to the music publisher who did the direct deal.
So this is the option for everyone to just go statutory and not make direct deals.
Yes. And then in the future, the people who have direct deals right now might go pure statutory with the MLC. You know, that's undecided, but the option is there, you know, to see how it works out.
And it's my understanding that Apple's generally direct deal and Spotify's generally statutory, as to the two big ones in the United States. Is that?
Yeah, that's correct. And I must say, we can talk about the appeal eventually, but Apple was the one sole digital company which did not appeal the rates.
Yeah, and in fact, they were the ones that offered a per stream rate.
Yes, they did. No, not saying that rate per stream rate was acceptable, but it was a concept which you know the NFPA and the songwriters organizations appreciated, because that's the direction we wanted to make it simpler than more complicated, but it didn't turn out that way. But the rates, that at least the initial rates, we felt were a real improvement over the prior rates for pre-2018.
Yeah, I guess the one thing I would add on the CRB is that the 44% increase is based on the headline rate, and that there is also an effective rate that was previously in place, at least with Spotify, that was a bit higher than the previous headline rate. I think it was, if I remember from our infographic, it was something around just north of 13 cents on the dollar, so around 13%.
Yeah. Now, do you want me to talk about the appeal that happened? And I won't spend much time on this, but if we want to save that, we can.
No, if you want to kind of maybe just quickly summarize it, and then we can talk a little bit with Dawn about some of the streaming issues, the
the four major streaming services other than Apple appealed to the U.S. Court of Appeals of the District of Columbia. The case was argued on March 10th, 2020, decided on August 7th, 2020. Basically what the Court of Appeals did, they appealed on a number of levels. The Court of Appeals affirmed the fact that any rates that were established would be retroactive. So whatever happens here, January 1st, 2018 is going to be the effective rate for all of these increased rates. They did remand it on a number of issues, some of which procedural, one of which was somewhat substantive. One of the substantive ones had to do with the definition of the mechanical rate with respect to bundled offerings. Now, bundled offerings are becoming more and more popular. In fact, Apple today just is introducing a bundled offering for, in fact, bear me with, I just read this article, for about $14.95 a month, which includes video streaming, music, Apple TV, et cetera, et cetera. The big question is what is the music aspect going to be worth? And that's one of the areas that the digital companies have appealed, because they didn't particularly care for what the rehearing by the CRB. There were other areas about the percentage of the revenue that the record companies pay to that the digital services pay to the record companies was one of the factors to determine the mechanical rates. It was an uncapped situation where it was capped before. That was appealed, and two or three other things. So we will see what happens. There's one substantive thing I believe, in my opinion, is the bundled area. Just how music is going to be valued. But we'll see what happens. The interesting thing is, here we are with, and the question is, will there be interim rates since a number of rates were vacated? That still hasn't been decided. But starting in March of 2021, we're going to start negotiating the new CRB proceedings for rates that will be effective in 2023. So here we are in a situation where we've got rates being appealed, and in a few months we're going to start negotiating rates that will be effective in 2023. So it's an odd situation, but it is what it is. What happens when the digital companies appeal the CRB.
All right. Thank you, Jeff. Don, you wanted to talk about a little bit about the streaming royalties and how they're calculated by the digital service providers, and a little bit of the current controversy on that.
I do. So let me first explain, just so everybody understands what the issue is, how streaming works in terms of dividing things on the master side, because it's simpler than the publishing side for all the reasons that Todd just gave you. But on the master side, it works like this, because there's only one owner and only one set of rights. They take the total number of streams in a month, and let's say it's 1,000, just to make the math easy. It's obviously billions, but let me just take 1,000. There's 1,000 streams in a month, right? And then they take a pot, and in the pot they put all of the subscription revenue and all the advertising revenue that the digital service provider got for that month. So let's say that's $1,000, again, just to make the math easy. So $1,000 worth of revenue comes in, there's 1,000 streams in a month. Now, if you have 10% of those streams as a record company, you would get 10% of the $1,000, or you would get $100. Okay, $100 comes into you because that was your proportionate share of the streams, which sounds perfectly fair on its face. And the idea would be, the more the people listen to your music, the more money you're going to get paid. Although the pool of money doesn't change. And by the way, this is, I won't diverge too far from it, but this is the most profound change in the music business in its entire history. And the reason I say that is because the time the music business started, back in the days when we had piano rolls and wax cylinders and sheet music, people monetized music by selling an object, by selling something, okay? And that's how the music business was until streaming came along. Now, for the first time in history, it doesn't matter, because if you bought a CD, the artist and the company got the same amount of money whether you listen to it once or whether you listen to it 1,000 times, right? It didn't matter. Now it does. It matters because, as I just explained, the more people listen to your music, the bigger percentage of the revenue you're going to get. More importantly than that is, we have a finite pool of money every month. It's the subscriptions and the ad money. That was never true. If I had a big hit, there was, in theory, no ceiling on how many of my fans could buy it and how much I could make. Now there's a ceiling on how much money there is for everybody in a month. And what that also means is that we're in competition with each other, because the more people listen to my music, the less they've listened to yours, because my percentage changes. The more they listen to you, I get a smaller piece of the pie, right? So we've profoundly shifted the model of the way the economics work. And it's changed the way music is marketed, because now it's all about how many people can I get to listen to my music. Just to give you a small example of it, again, it's out of my expertise, but I have enough to sound like I know what I'm talking about. There's a difference between what they call lean in and lean back music. Lean in is when I'm actively looking for new music, trying to discover, looking around, searching. Lean back is, I just want you to entertain me. Give me a playlist that somebody else made. Let me listen to my own playlist. And the key in streaming world is to get on playlists. You want to get on people's private playlists because that's the best. That's the one they're going to listen to the most. And you want to get on the well-respected playlists that are put together either by influencers or by the digital service providers. So we've completely shifted the way that music's monetized. We've completely shifted the way the ecosystem works. So out of that comes an interesting issue, which has a little momentum, but not a lot. But it's a fascinating issue, and so I think it's worth knowing about. And that is the system that I just described, take the number of plays and take your percentage and pay the money, a fair system? On its face, it sounds perfectly fair, but consider this. Let's suppose, just to make the example easy, there's a streaming service that has two artists on it, Fred and Lisa, okay? And let's suppose that there's two subscribers to the system only. One listens only to Fred and one listens only to Lisa, right? Two subscribers. So they each put in, call it $10 a month, but Fred only listens, but one subscriber listens only to one artist, one listens only to the other. Now, that sounds interesting, except what if the guy who listens to Fred listens 900 times and the person who listens to Lisa listens 100 times? So under the system I described, out of 1,000, Lisa's going to get 10% of the total $20 of subscriptions, and Fred's going to get 90% or $18, right? So comes the issue of, is that fair? In other words, should the person that listened only to Lisa, who only played it 100 times, should their full $10 a month be allocated to Lisa? And that becomes a pot. And obviously, it's way more complicated than I'm making, but that's the basic theory of it. And there's a certain innate fairness to that, because that way my fans are really listening to my music and I'm getting the benefit of that. Whereas they may be small but devoted group, but they may be listening heavily to my music and I'm not getting the benefit because I'm completely drowned by Drake and some of the others that just overwhelm the system and take most of the money. Now, is that going to happen? There's talk about it. There's not a lot of momentum behind it, but there's some. There's an article, the only article I've seen, which is old and was based on a study in Finland and not that reliable, showed that the swing was about 3% if you switched it from a per user to a per stream model, and from the per stream that's currently in place to a per user model. So it was about a 3% swing. It doesn't sound like much, but 3% is a lot of money, and 3% allocated down to the smaller artists is really meaningful. Now, the problems with it are that it's really expensive and it would mean revamping the total system. There would also be the politics of, I'm a major artist, am I going to be giving up money under the current system to fund some of these smaller artists? Some of them may be okay with that on a fairness, some of them may not be okay with that. It depends. So I don't know that there's a lot of momentum for it, but it is out there, it is rumbling, and at least from a fairness standpoint, it seems like it could be a better model.
Well, it certainly sounds, Don, it sounds like it could be fair for the smaller artists. Are the DSPs behind it at all, or are they kind of, because of the complexity and the expense to implement, more reluctant?
They're more reluctant. It would cost them a lot of money to do it. And right. To them, it doesn't make any difference to them. They don't, in a sense, care where the money goes. They've got a finite pool, they get the percentage, and how the rest gets allocated doesn't matter. So there's no particular, and they're trying to say, hey, it would cost us more than it would be worth, and blah, 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 blah. And that's true in the short term, but in the long run, it would be more fair to do it the other way, I think.
Got it. Yeah. Obviously, there's some, like you said, there's some politics, probably the possibility of taking money away from the top selling artists. But it looks like we've got a lot of questions coming in. So I just want to let people know we've got a lot of information that we're trying to get through. So we're going to try to leave questions towards the end. We'll probably leave about 10 minutes, hopefully, to get back to some of these questions. So just to move along, obviously a lot of people have been wondering how things, the effect of the COVID-19 on the music industry. I think, generally most people understand that artists make vast majority of their money on touring, and there's certainly been an effect on that and on the distribution. But let's talk about a little bit how artists are trying to compensate for the losses of revenue. Don, did you want to start us off? And I'm not sure this is a direct reflection of COVID, but I know you wanted to talk about the sales of music catalogs, unless we wanted to talk about live stream events first. But Don, why don't you start us off?
Okay. The live stream events that I've seen so far have mostly been around charity and very small sort of things. So there's no particular model for it. I personally think that, live streaming music is not, at least today, isn't the greatest experience and not exactly what people want. It may be what they have to take in this environment. I haven't seen any serious models or serious money moving. I've seen big numbers for the ones for charity or freebies and so forth, but I don't think there's any particular model on it. I do want to talk though about the sales of catalogs, but Jordan, did you want to add anything on?
Sure. Yeah, I mean, look, there's nothing that's going to make up for the total loss of touring that we're facing right now. It's just impossible to make up for the revenue loss and the devastation that our entire industry has felt. There's ways to kind of chip away at it, and I think the live streaming bit is one of them. I've seen for clients various brand endorsement deals that have live stream elements instead of a live show that have come with a relatively significant amount of income. I've seen also really great fan engagement through live streaming, like a client of ours, Ben Gibbard, for a while did him and a guitar in his living room and taking requests, and it was amazing client customer and fan engagement. But yeah, I mean, I think we're just trying to trudge through and get to a place where we have a vaccine and where we can have large social gatherings again. I do think that, and to, I guess, bring us back to the catalog acquisition, there's a lot of activity there. I think the numbers that we're seeing through the pandemic in terms of revenue generation from music consumption, while it initially dipped, it's now kind of raised back and normalized and is slowly gaining. I mean, the RIAA's mid-year report shows a gain of about just over 5, maybe 6%. So IP through a global catastrophe is doing well. And I think that's going to help continue the ability of IP sales. I mean, my firm has done about $500 million in catalog acquisitions in the last 12 months. And it's just amazing how many A, people are out there looking to buy, and B, how many people are out there looking to sell. I mean, when I started as a lawyer, you wouldn't sell your catalog until you were 60 or 70. And now we've got people selling up to a point and then making more hits and then selling again. And you're seeing clients that will, they're 25, 30 years old and they're like, my biggest hits are yet to come. So I'm going to sell this, invest it smartly, put it in a nest egg, and keep writing hits in a safe space financially for my family. And I think the pandemic is encouraging more people to do that to make up for lost touring revenue.
Don, you want to jump in?
Yeah, my view on that is, well, first of all, I try to talk people out of selling in the sense that historically, everybody who has sold their songs has regretted it, or sold their masters has regretted it. I mean, for example, Led Zeppelin sold their royalties on their catalog. Elvis Presley sold his royalties. And historically, those turned out, while they were maybe good deals at the time, not to be such good deals in the long run. So barring circumstances that are a bit unusual, for the most part, I try to talk people out of it. Don't always succeed, and frankly, not in my own interest to talk them out of it, but I try to look out for what I think will be best for the client in the long run. The circumstances where it does make sense, or older people where the heirs have no interest in it, or the heirs don't get along with each other, somebody who really needs money can make some sense. There's certainly tax advantages to doing it in terms of you can get capital gains on the income if you own the copyright, not if you're selling an income stream. So I think there's reasons to do it, and we've certainly done a number of sales with people that are sophisticated enough to understand it and are just entrepreneurial business people who know exactly what they're doing. So it can happen. What happened, though, was interesting over the last year. Merck Mercuriadis, who runs hypnosis, single-handedly ratcheted up to a massive degree the amount of money that's paid for the catalogs. And what happened was a confluence of a number of things. The economy in general was a bit shaky, and music has been on the rise, growing in double digits over the last few years. They are, and suddenly that attracts Wall Street. Wall Street likes things that grow at double digits over a period of years. They suddenly perk up, get interested. Secondly, if you're dealing with a pension fund, if you're dealing with a large fund that needs to show a 5-6% return, maybe a bit better, 7% return, those are good numbers for them if they're steady and they're reliable. And if you look at music catalogs, particularly iconic and classic ones, where they have a long history of earnings being very stable, and you couple that with a pitch about streaming hasn't yet matured in all territories, it's got a long ways to go, so the income's going to be growing. You have a steady source of income, an iconic name you can brag to your friends at a cocktail party about, and you have a potential for growth in the future. And that's made for multiples to go up higher and higher, because historically the multiples on songs were in the 10-12% range for good stuff, maybe 16-17 if you had a catalog that was way under utilized and never been promoted, and they thought they could do it. Now the multiples have gone, for the right catalogs, well into the 20s, and that's a pretty profound change in the way the business works. And people are saying, hey, this is a historic moment, to take advantage of it, and maybe it makes sense to do it. And there's a lot of money chasing it. It's not like there's one or two players. There are, I get calls from new hedge funds starting up with some guy from the business almost every few weeks saying, you got anything? So there's a huge demand for it and a lot of people chasing it, and a very interesting market.
Hey, Pierre, let me jump in.
Yeah, absolutely.
Yeah, and I'd love to be in private practice with you guys. Very lucrative. I tell you what, because being in B&G, a lot of my role has to do with due diligence on catalogs and also negotiating the various deals, et cetera. I do want to mention my brother and I did an article called "Buying and Selling Music Catalogs for the Entertainment and Sports Lawyer," which is the American Bar Association, which is the winter of 2020. So any ABA member might want to look at that, because we get into the due diligence aspects of what do you look at when you're evaluating catalog and how do you project income. But going off what Jordan and Don said, the acquisition area is fascinating because there are so many variations. You're just not talking about selling everything. You've got writers selling their non-performance income, writers selling their performance income, writers selling both writer and non-performance income, companies writers selling their publishing rights. There are acquisitions of larger companies with static catalogs, which are easier to do diligence on. You've got catalogs being bought and sold that have active writers. So you're not only buying a static asset, a fixed sum of songs, but you're looking at obligations into the future. There are also writers who are keeping a portion. I've seen one deal recently where the writer has kept 10%. He's only sold 90%. So there's a slight hedge there. I've also seen deals, I think as Jordan mentioned, of selling your back catalog to someone with a going forward basis. So that not only have you gotten monies from the back catalog and hopefully take advantage of all the tax advantages if you own the copyrights, but you're guaranteed money on a going forward basis. And you've got to be an active writer, obviously, to get one of those deals. But the variations are absolutely fascinating. And, there are restrictions on selling writer royalties. For example, ASCAP, you can only have an irrevocable assignment if the writer has made a certain amount of money during a certain period of time in the past. Any other assignment is revocable. Now you've got rights on the contract, but it's a fascinating area. The projection of income in this area is extremely complex and interesting. You've got to be constantly looking at what source of income is decreasing, what source of income is increasing. You're also looking, if you're buying publishing companies with writer contracts, are there lots of restrictions in the writer agreements, which might prevent you from, exploiting in the best sense of the word, and promoting the songs without permission from the writer. So all sorts of things go into these negotiations, into the due diligence aspects and everything else. But absolutely fascinating area, and I agree with both of you. The money flowing around right now is just amazing, but you've really got to think about your future. Do you want to sell an asset, for lack of copyright, or where you're never going to see another dime again, or do you want to take the money now, or do you want to do somewhere in between, or some aspect of your royalty stream?
Because think about it. The reason these companies are acquiring these rights is because it's a good deal for them, right? So you're selling these rights, and that's what I tell clients. I'm like, okay, let's say you get a 25 multiple. They're prepaying you for 25 years of earnings. So after year 25, if you're a 30-year-old person, from 55 on, you're not receiving any of this money ever again, due to the fact that you're taking it now, right? So it's really interesting to look at. And to go back to Jeff's point about the complexity, it's almost like insurance now, where you can insure basically anything. You could sell anything. And, the restrictions for these new writers who are currently in pub deals and they're selling a right that stems from that pub deal. Well, what happens if they take an advance in the next period? Is the publisher now not allowed to recoup that advance against the compositions they sold? No, they would need an agreement for that. So what's in the publisher's best interest to give that agreement other than to keep the writer happy? Like, why would they do that? So there's a lot of interesting stuff. Also, like we, if you look at historic jazz or blues musicians who've been previously grossly underpaid in royalties, is it worth going back to the various rights holders to get the royalty up before you sell? Because then that increases the base, which you attach a 20 multiple to $100,000. That's there's $2 million more. So there's so many interesting issues. And I'll say one more thing and I'll stop talking, but the art versus science of figuring out where the contemporary songs are going to settle, right? Because if you're selling a current hit, it's not going to make the same amount of money in 10 years, 20 years, 15 years. And so it's where will this track settle to apply the multiple? So you have guys like Merck, and you're hearing these stories of 22 multiples, but what's that multiple on? Because if he thinks it's going to settle somewhere at double of the other base, then you're at an 11 multiple. So it's just, it's a lot of fun. I agree with Dawn that, I try to talk people out of it as well. Some people just, they want to do it. A lot of things I'm seeing with hit songwriters that are producers is that they're in the studio, and these guys and women, they're talking about it in the studio, and it's almost like a competition who can get more. And so it's an interesting kind of community ecosystem of, well, he got 12, I want to get 14. It's like, no, don't think about it. It's not about that. It's about an annuity for the rest of your life. Right. But, you can only do so much, right? It's not your decision at the end of the day.
And I must say, multiples you always back into a multiple when you look at the final sale. You're right, Jordan. Depends what the multiple's based on. If there's $1 million earnings and we cut it down to $700,000 because of audit settlements, litigation things that may not occur, bonus monies from ASCAP and BMI, which will never reoccur again on contemporary hit songs, or may never reoccur again. So it depends on, you can knock $1 million down to 700,000, then put a multiple on it. So multiples, to me, there are a lot more factors than just multiples, as all of us know. It's the cost of money, it's, et cetera, et cetera. There's lots of issues going on there, but fascinating stuff.
Have you guys seen any changes in the creation and releasing of content caused by COVID by artists? I mean, I've heard stories of a lot of just kind of artists focusing on creating new music, kind of, a lot of it can be done from home now, but are they waiting to release it until things, go back to normal? Are we going to see a backlog? What have you guys heard?
I think we're going to see a massive backlog on touring. I don't think we'll see a massive backlog on releasing. They can make and release records from home pretty handily, as Taylor Swift just did. What you can't do, though, is you can't do the promotion you would do before. For example, it's much harder to make a video because you have to get a crew and people together. You can't go out and meet people or talk face to face with the press or do any kind of a junket or tour. So the promotion and marketing is much harder, but the ability to make and release good music is still there.
Yeah, I agree with Don. I think, when people aren't touring, they have more time on their hands to create. And, with companies like Splice and BeatStars and other do-it-from-home creation portals, the possibilities are pretty limitless for modern-day creation of music. And at least from my end, I'm seeing a lot of it with my clients. I think we're on par to do about 1,000 clearance agreements this year with producers or features or mixers. It's an insane volume based on the collaborative effort of creation now, that you can send something to someone and they can add their bits and send it back to you, and then you can add your bits. And I mean, Taylor Swift's album is a perfect example of that. It's an amazing record front to back, and the way it was produced is modern day music production.
Why don't we switch over to how's COVID affected songwriters, composers, publishers? Jeff, you want to weigh in on that?
Yeah, I'll be happy. I'll really try to take this fairly briefly, but I'm going to hit the major areas. Television, one of the main ones. There are about 485 scripted shows last year. Now, scripted shows have episode numbers from 8 to 22 to 24. So you're talking about that much product in the TV pipeline that is going on during one year. And obviously, all of those episodes basically use music, especially the dramatic series. Could be hit songs, could be indie songs, it could be background score, you name it. Obviously, most of the series shut down in March or so. So you're talking about 6 months now with basically almost no dramatic series being produced. Now, there is production starting a little bit, but what's happened is that basically you've lost 6 months worth of synchronization income for composers, obviously 6 months of composing fees, et cetera. That also will translate into performance rights payments. Because let's say, let me tell you, the one place we haven't been heard, at least music publishers, you have to have the right catalog, are the music-centric shows. The Voices, the America's Got Talent, et cetera, Dancing with the Stars is on right now. Those shows are still on, and the Voice is coming up shortly. So those are still licensing music. But I'll give you an example. If we have a song on the Voice in, let's say, March of let's see, this month, which is September, that's the close of the performance rights quarter. We're not going to see that money for another 6 months. So there's going to be 6 months worth of performance royalties, which are not going to be there because the shows we're not filming and not licensing money. So there's going to be a huge gap. Not only are we losing synchronization fees, but we're going to lose the expected performance income from those fees, which will show up six months from now. That's one of, on the air promos, there are, that's starting to happen again, where one of our songs is being used in a promo for a TV show. But the scripted series shutdown has been really, really devastating to a lot of people. Motion pictures, fascinating. None of the composers, none of the people who license music to films are hurt by the lack of theaters, opening in the U.S. because there are no royalties. There are no performance royalties for theatrical performances in the U.S. Where it's hurt everyone is overseas, where there's, performance royalties that are collected by the local performance rights societies and then distributed back here to ASCAP, BMI, GMR, and CSAC, or to the local sub-publishers for the publisher share in the foreign territories. That's been devastating, with the theater floating down. And when you're looking at and overall, my brother uses 1% of the box office receipts for these type of composer, songwriter royalties. It varies from countries. There are culture deductions also. But when you look, that's an awful lot of money being lost for a period of time. So we lost that. The positive aspect is that with all these films going to the digital services right away, you're going to see performance money prior to the time that you would have seen it, because there are no windows anymore almost in the U.S. for theatrical, supposedly theatrical released motion pictures. The other interesting thing that's happened is because so many films are going direct to TV as opposed to theatrical release, many film producers are asking for not theatrical or media licenses, but basically almost US and Canada TV licenses with an option for theatric outside the US. So different types of licensing, which can mean different types of fees and probably lesser fees in most respects. So that's what's happening in theater. Commercials, for the larger publishers, we've not really been hurt that much. More people are watching TV, more people are watching services. The advertising agencies are trying to figure out how to appeal to certain buyers. I can tell you right now that the songs that are being chosen, the pre-existing songs, are more uplifting songs. Like Rise Up or What the World Needs Now, I'm looking at our catalog, but songs like that. So we have not been really hurt. The interesting change, though, that a lot of the advertising agencies are coming in for shorter term commercials because they're trying to figure out what works. There might be more regional commercials as opposed to national, 1-year commercials. The media, sometimes, they're not going for TV, but other media, social media, et cetera. So there's a whole change there. But, we've not been hurt there. Video games has not decreased at all. In fact, in some respects, it's increased. With the number of people playing video games right now at home, the music and dance-centric games have been great for us. You've got the downloadable content that if your song is not in the game, you can download it for 15% of the retail price, or 15% of whatever the price is. That's been very, very lucrative. And, these video games, especially the music and dance-centric games, the advances are substantial. And my brother was telling me that he mentioned to me that there are going to be new consoles coming out from the large video game producers. That's going to generate a whole new group of people watching video games. And being at home has changed the face, not has changed the face of video games, but it's really increased the area. Broadway, musical theater, disaster. Absolute disaster. When they close down the theaters, I'll give you one example of the type of money that can be made. Many years ago, I licensed one song to Jersey Boys. One song, was earning about $120,000 to $150,000 a year from road tours and Broadway, et cetera. Talking about one song, you talk about shows that have 10 songs, 15 songs, et cetera. The amount of money that's generated, it's zero right now, other than a few of the plays going on to the digital services where the performance royalties are not that good. Lastly, performance income, I'll be very brief about this. General licensing has been really, really hit hard. Bars, concert venues, et cetera. There's no such thing as, your performance concert royalties from ASCAP or BMI, the Performance Rights Society, because there are no concerts. The foreign societies are having the same problem, so there is going to be a dip in performance income. It will last for 6 months to 9 months, and hopefully things will come back. But performance rights societies have mentioned it to their members that could be anywhere from 10% to 12% to 15%, depending on what area you're looking at. But there's a decrease there. The good thing about performance rights societies, they're making more and more money from the digital services, which has compensated a lot of the losses for the general licensing and some other areas. So there are pluses and minuses in all these areas, other than Broadway, it's just, I feel sorry for those people, total disaster, total.
Jeff, have you seen, I think we talked about there's been some buyouts of performance rights like Netflix. Do you want to talk about that a little bit?
Yeah, I'll be brief on that. There's there's something going around right now from some of the digital companies, one of which is Netflix, where they're asking, requesting, demanding. I don't want to use the whatever word you want to use, is that the composers take a one-time lump sum fee for their services, where it's basically a buyout of all performance rights. And that would destroy the future income of composers. Composers live on, the streaming or the TV performances, et cetera, the back end of their composing fee. The SCL and Your Future, Your Music websites, so the SCL being the main composers and lyricists guild for film writers and TV writers, they're fighting it. People should go to their websites and just look at what's happening right now. But it's a trend. It's a dangerous trend. And the composers are really fighting it, as are music publishers who have existing songs, because that same scenario is coming our way as well, and we are just basically saying no. As simple as that. So a lot has to do with bargaining power, though. We all know that. But it's a bad trend and a bad thing that's happening right now.
Well, we've talked about artists and the songwriters and publishers. Let's talk a little bit about the labels themselves. Don or Jordan, have you guys seen or any of the labels change their approach, strategy to contracts at all? Is there anything that they're doing differently now because of maybe from the effects of COVID, getting a little more conservative with their agreements or anything like that?
Well, they happily use it as an excuse when they don't want to pay something.
Can't imagine.
We hear a lot of COVID when they're trying to be tight on the deal, and then if they really want something, suddenly not so much COVID. I'm Jordan. I don't know your experience. I have not seen a huge change in it. The record labels are quietly doing pretty well during this period.
Yeah, I haven't seen much different before or during.
No changes in the advances or trying to make shorter deals.
Well,
we're always trying to make shorter deals.
Right.
We're the ones who want shorter deals.
Yeah, that's true. Yeah, they probably want the longer ones.
Yeah.
What about Jordan? I think we talked about this a little bit. Do you want to kind of talk about the CARES Act a little bit?
Sure.
Just what type of relief it's offering for the musical professionals, and is it actually helping?
Yeah, I mean, so back in April, I was part of my advocacy hat wearing. I'm on the board of directors of Music Artists Coalition, and we formed a coalition of coalitions, as it were, to all entertainment industry affected groups in music, film and TV. On the touring side, agency side, company side, records, publishers, songwriters, producers. We got everyone together. I think it was like 85 different organizations, and appealed to Congress to take care of music workers in that first CARES Act, and we got it. We were helpful in getting the $600 extra for all unemployed workers. We were helpful in getting independent contractors to qualify for state unemployment. We were helpful in the PPP Loan Act, being able to apply for touring artists who wanted to keep their staff on payroll. So there were some really great benefits under the first round. There were some huge holes that nobody could have predicted. Everyone was working very quickly. One of those holes is what's called the mixed earners issue. And so that is if you have both W-2 and 1099 income. So if you're an employee and an independent contractor, which most musicians are, and you have enough W-2 income to qualify for unemployment, for stateside unemployment, then that basis is what gets you your weekly and monthly benefits. So like, let's say I made $200,000 as a musician on 1099 income, but I happened to do a couple union gigs and made $3,000 as an employee. That $3,000 is your base, not the $200,000. So it significantly lowers the weekly benefit that you get. And now that the $600 is out the window and Congress can't figure out what to do in terms of agreeing on a new package, and we have this executive order muddying things as well, it's hurting mixed earners even more. I mean, in Hawaii, you can get as low as $5 a week. So that $5 a week is knocking out, the maximum in Hawaii, which I believe is around 350. So we have a ragtag crew working as hard as possible to try and get that fixed. Granted, we're dealing with a Congress that can't agree and a president that doesn't read. So it's, difficult to say the least. But I will say, I mean, just kind of to summarize that whole thing, got some good benefits. The mixed earners, there has been issues there. And we're still working to fix it. I mean, my Corona relief email folder has 6,000 emails in it. There was a time where I wasn't doing anything other than that. Fortunately, we have enough people working on it now that it's moving forward steadily. But it's anyone's guess whether something gets passed, period, and if it does, whether we fix that. The other major item to note is the Restart Act and the Save Our Stages Act, which has been sponsored by both the House and the Senate, various members in each chamber. And, that is the act to keep venues from going under, to give them some subsidies, to take care of them in this period of time between now and probably next summer when they can actually open and be profitable again. Those are both very key items of legislation that are necessary to keep our business running, or to keep our business running through this period. And those are also up in the air because Congress can't agree on any CARES Act extension, let alone our portion of it. So that's kind of the pluses and minuses of the involvement of the entertainment community with respect to CARES.
Great. So we're doing okay on time. So I'm going to try to get into some of these questions. I think this first one is dealing with the amendment to the AB-5. Jordan, do you know if the amendment covers music supervisors?
Music supervisors. I know it covers composers. I'm not sure if the language specifically covers music supervisors to the extent they're working for a film company. I know musical composers to the extent they hire other composers to work with them, or to the extent a film company hires them to create recordings. I believe that is covered. I'm not sure about supervisors.
Okay. This next question I think is related to the rate appeal. With the appeal pending, what rate applies now, and what of payments that have been made in the interim under the new rate? Jeff, you want to?
Yeah, it's just very interesting. There is no interim rate having been set so far. The CRB could set an interim rate probably, I think, in October, but currently the services are paying the current rate, the increased rate every single year. In fact, the statement I just pulled is the rate of the current 1 year period. We will see what happens with the interim rate. We just don't know. That's under discussion right now.
And Jeff,
but there will be a rate. It's just not going to stop. Question is what that rate is going to be.
Jeff, didn't they actually request a credit that first year from publishers based on an overpayment?
Yeah, they're still trying to get that in the negotiations. Yeah, it's a little complicated, but yes, they're trying to get a credit, among other things.
Will the MLC be advising people that they only collect the U.S. and give people options on how to deal with their foreign?
Yeah, the MLC is only for, first of all, audio interactive streaming in the United States. Outside the United States, most people go through their sub-publishers and the CMOs, the collective societies around the world for this particular right. So really, this is a U.S. right only. It's reciprocal only to the degree that we expect foreign societies to actually be members of the MLC so that we'll be transmitting the U.S. generated royalties to the foreign societies, or in the case of foreign sub-publishers who actually control their mechanical rights, which is somewhat rare, we'd be dealing directly with the foreign sub-publishers. But this is a U.S. only organization for U.S. streaming only.
Okay, Dawn, I think this question is for you, dealing with how the streaming royalties are calculated. As to streaming, does all revenue get distributed per your example, or only a pool share of ad and subscription revenue?
No, it's a portion. First of all, they take the pool and then they pay out somewhere in the mid-60s% between publishing and record companies. The percentages are a bit confidential, but it's somewhere in the mid-60s, a little bit higher, maybe a little bit lower, somewhere in there. And that goes to, and then they keep the other for their profit and for their operations.
Great, great. Does somebody, we got a question here about enduring any litigation involving force majeure clauses or guarantees. Anybody want to talk a little bit about force majeure?
Well, there is, I think it's the Virgin Fest has sued some agencies over the cancellation surrounding around a force majeure issue. We had a client that we're not in the litigation, we settled, but yeah, I mean, it was from what I recall, it's a pretty unique interpretation of a force majeure clause, but I would expect to see panicked investors in festival properties use whatever they could to claw back money that was paid to artists when the festival didn't take place.
Right, right.
And my experience with it is it depends. It's very contract dependent as to what the language is on force majeure, as to whether there's an issue. But there's a big picture, overarching reality, which is because the artists in theory could be asking for the balance of their fees, even though they weren't able to perform under the force majeure. So there's a balance that nobody wants to drive the promoters out of business. The promoters can't survive if all the artists come in and say, pay us as if the festival happened. Their business, their income spigot got turned off completely. And nobody wants to do that. So for the most part, everybody's compromised. They'll roll it forward. They'll make some sort of a settlement because they don't want to, it's a mutually assured destruction. The artists need the promoters and vice versa.
Yeah, we're seeing that too. It's like, what's the right thing to do here?
Right.
And that's where the conversation generally starts and ends.
Does somebody want to talk a little bit? I got a question here about if anybody has anything to say about the Save Our Stages Act.
Yeah, that's what I mentioned in when I was talking about the CARES Act and the extension of that. I mean, that is what NEVA and a few other coalitions of touring professionals and venues are pleading for it so that they can keep their businesses. It's essential. It cannot be overstated how important it is to get relief to the hardest hit industry in our country. I mean, we only do large social gatherings, and for these venues like the Bluebird, it's a small space, and a lot of people go in there for it to turn a profit, and that's not going to happen for a long time. So I think that we will be one of the last. That sector will be the last sector of industry to go back fully online through this pandemic, and it needs to be acknowledged and understood in Washington, and they need to be taken care of.
For attorneys who represent self-published artists, what would you guys say are the most important actions for them to take to protect their artists' interests regarding the MLC?
I would say be vigilant about registering and making sure that the information is accurate and that the percentages aren't in dispute, and then you'll get paid. To the extent, and Jeff, maybe you can answer this, but like to the extent a company like Apple is going direct to most people, they're not going to cover the self-published writers. How does that money get paid? Does Apple then pay statutory on the rest through the MLC?
Yes, in fact, it's essential for the self-published songwriters or composers to join the MLC, because basically there's going to be a portal where you can go in and check your works, just as Jordan's saying. registration and accuracy is the basis for payment. It's as simple as that. And anyone who does not take advantage of it is a fool, absolute fool. So it's registration and just diligence and looking at the tools that the MLC will give them to make sure that their songs are registered correctly and that there are no counterclaims, and if there are, they can be resolved. But registration and just checking your catalog and asking the MLC to compare what you have in your catalog with what they have in their records, because they'll send you reports back about the discrepancies. So essential. It's all for free too.
By the way, just for a little bit of fun, for those of you out there, have you wondered why the digital service providers would pay for and fund an organization to collect money and let the organization pay 100% of that money go out elsewhere? Doesn't that seem a little odd to you? Let me explain.
Well, because they're getting a waiver of liability for infringement for doing that.
That's exactly what I was going to say.
I know. You wanted me to say it. You're probably saying, is Jeff going to beat around the bush in this question?
No, it happened because they were getting sued left and right in class action lawsuits for copyright infringement because it was so overwhelming that they couldn't comply with the statutory procedures, and that's the reason that all of a sudden we had a kumbaya and came to an agreement to set up the MLC.
Yeah, we're hoping that this is a win-win for everyone, especially with the unmatched royalty situation, because there's a large amount of money which is unmatched right now. So we'll see what happens.
Here's a question. Have the independent publishing administrators such as Songtrust entered into direct mechanical licensing deals with the DSPs, or will the indie administrators be collecting from the MLC based on statutory licenses?
That sounds like a Todd question. I mean, sorry, a Jeff question.
You want Todd to sit in my chair, Don? He's in the next room, as you know.
Are you guys ready for the switcheroo?
It already happened.
Yeah, well, the bad thing is Todd didn't sign a speaker release, so he can't say anything.
True,
okay?
true.
I'm not sure if Songtrust has a direct deal, they will probably stick with their direct deal. We're hoping that they go through the MLC. But it's their choice, and it's the people who have signed up with Songtrust, what they want to do. But I don't know the answer to that, but I can find out, definitely.
Okay. Let me see what else we got.
Can I say something about the music supervisor's question for AB?
Yeah.
I've been thinking about it ever since it was asked. There's other exemptions in the actual AB-5 bill. There's a business-to-business exemption. So if you're a music supervisor and you run your own business, you might be able to fall under that exemption anyway. So it's just worth looking into the facts around it. I mean, you could also email me or call me, and I can help you with that.
Great.
Question.
Also, just to remind you, there are questions in chat as well. You can check them.
Yeah, we still got a ton in Q&A too. We still got a little bit of time left. So here, I'll jump over to the chat.
We can go a few minutes over time if you want to.
I can't. I gotta go at 2, but sorry.
I think I do as well.
I got a hard time.
No problem.
Lawyers, we're right on time, on the hour.
Wait, wasn't there an old TV program called Stump the Stars? That's what kind of thing we're doing here.
Bring it on.
Let's see. Sorry, some of them are repetitive from the Q&A section, so I'm trying and then want to get you guys.
This Kanye question's interesting.
Yeah, you want to jump on that one, Jordan? Read it.
No, I don't.
No, let me see if I can find that one again. I don't know if anyone wants to take a shot at it.
It's what is your take on Kanye releasing his Universal contract to the public? How will this hurt him or help him? And do you think we will see a trend of more artists / new artists trying to renegotiate or forego the label contract? I will say that a lot of artists are foregoing the label contract. I mean, anytime an artist comes to me and says they want to release music, what should I do? Well, I ask them, well, what are their goals in the next 3 to 5 years? What kind of resources do they have? What kind of resources do they need? And then we go out and see from all the range of options that artists have to release music these days, whether it works, it makes sense to go to like a DistroKid all the way up to like a Universal. It's not one size fits all by any means. So I think that's happening more and more. And frankly, you know, the artists that self-release and do well on streaming, they make a really good living. You know, I know AWOL put out something that said a lot of their artists are making more than $100,000 a year in streaming, and that's accurate. You're looking at about $5,000 on the record side per million streams, and it goes down and it goes up every period. But you get 100 million streams, that's $5 million. You get 100, you get a million, you get 10 million streams, that's $50,000. So it can be a good ecosystem for longevity for new, established, and even brand name artists.
Hey, Jordan, let me mention, because I looked up one thing on one of our statements. I'm not going to give you the service, but 65 million streams equated to about $57,000. So if you're up there, but no comparison with radio, though. I mean, we had one song that came in.
That was on the publishing side, right?
Yeah, that was on the publishing, but the writer would get the same thing.
Right, but I mean, if you own the record, you're getting, 5x that.
Exactly.
Here's a question. How does the MLC plan on reaching a consensus with potentially conflicting information, metadata, for songs included in the portal?
Basically, we are not making any judgments. We're not arbitration either. All we're doing is we're letting the parties know that there are discrepancies between the information, and they're going to have to figure it out themselves. Obviously, we're going to be holding royalties in many situations if they're legitimate claims. So we're still there are still rules being promulgated, not only by us, but by the Copyright Office. We're still waiting for a number of regulations from them. And so a lot of this is still up in the air. We're going to have pure regulations by the time January 1st comes along. But that issue, we are not going to make judgments as to, in disputes, as simple as that.
How much has social media apps like Snapchat and TikTok impacted the revenue streams for composers and artists? Is it starting to become a significant revenue stream?
I'm not seeing it.
Not yet. No, they're only recently starting to monetize.
Yeah.
I mean, what I know, like some settlements with TikTok and Facebook, it's like this lump sum that's supposed to go to everyone and then divided via market share. And it's take it or leave it, because we have DMCA safe harbor protection. Come get us if you don't take it. It's kind of the vibe on those.
Okay, we got about 5 minutes left. I wanted to kind of generally ask you guys, what future trends are kind of being pushed faster into the forefront because of COVID? What do you guys seeing? I think Jordan, you might have mentioned some of the brand deals in the virtual world now. Is there anything else you guys want to touch on as far as any changes either caused by COVID or just that you're seeing here in the near future and going forward?
I'm not seeing a lot in the way of what I would consider permanent changes. I think that everybody just assumes there's a pent-up demand, and when we have the ability to go out again, things are going to go back pretty much to the way they were. I haven't seen anything that I think is going to be permanent in terms of that.
I would say in terms of things that touch our business by way of media dollars, I think it's speeding up the transition from traditional to digital media. I mean, it's been heading in that direction anyway, but I think more money is going to go on, is going to stay online when we come back. And I don't know about the live stream stuff. I mean, maybe that sticks and is something that is an additional revenue stream on the touring side, but I don't know.
I guess my only comment is for artists, songwriters, composers, lyricists, you name it, to really pay attention to business. This is a brand new world we're entering into. I agree with Don. There's still, there'll be more platforms. The basics are still there. There can be there are a lot of avenues. There are going to be some very strange deals out there that, may or may not be monetizable. They might look good on paper, but it's just awareness that you're not only an artist, that you're a business person as well. I think that's essential.
Yeah. And I tell clients it's complicated, right? Like, it's very complicated, but, read Jeff's and Todd's book, read Don's book.
Yeah.
And it's, once you get it, you got it. It's not, it changes in terms of, how money flows and where it comes from. But in terms of the rights array, it once you get it, you're not going to have to relearn this all again in 5 years.
Yeah.
Although starting 5 years ago, you couldn't have said that if you had,
fair enough.
if you had a crystal ball.
Hey, Jordan, just a follow-up question on the AB-5 amendment. Do you know if how that's gonna impact, or if it impacts any of the other industries like film or television?
Everyone has to go out and get their own exemption, it seems. They painted with a very broad brush. It applies to everybody in California, and to the extent your industry needs the exemption, you gotta go get it. It sucks. And as the guy that literally was in the middle of it from August of last year until now, it's a lot of work, but it ends up being worth it. I think the only overlap we have in film and TV is with respect to composers.
I have a question here. Don, this is for you, Don. Are any of your major label artists re-recording their previous hits during COVID?
There's one prominent artist who has talked publicly about re-recording, but I don't want to get into too much specifics about it, so I'm going to decline to comment on that.
Okay.
I must say, it is something that's happening, for artists who have been out of their deals for a long time to re-record their masters. I mean, they've got to have their voices, and the group has to be together. But there are lots of alternate masters out there. In fact, we represent a number of publishers do as well, for some of our writer-artist clients who re-recorded.
Yeah, the modern record deals don't let you do that. At least they don't let you make a sound-alike of it, if they let you do it at all. The older record deals and the classic artists, you could duplicate your master, and a lot of them have done it. That's pretty widespread. And in fact, they will say, if you want me to license the song, if they happen to control the song, you may want to use this master, because they get all the money instead of sharing it with the record company.
Yep.
Okay. Well, I think that wraps us up. I just want to thank you guys. It's been fantastic. It's been fun. Been an honor to moderate this panel for you guys. I really appreciate you guys being on this. And to everyone watching, if I didn't get to your question, I apologize, but we tried to get to as many as we could. And you guys, hopefully you know how to get a hold of these three guys and follow up with them. And I'll leave it there. Thank you guys very much. I don't know if anybody wanted to say anything.
Thanks, guys.
Thank you.
Thank you.